Hi, everyone. So we're just going to wait a couple of minutes just to let people filter in before we get started. Okay, so it seems like people have started to filter in. So welcome again to our Fundamental Freedoms Programs briefing. Just before we get started, I have some quick housekeeping announcements. So this event is being recorded. We will make the recording available to you after the event. Your cameras and audio are off, and they will remain off for the entire briefing. We have time at the end for a Q&A, so please post your questions in the Q&A section and we'll try and get to as many as possible. I'd like to take a moment for a land acknowledgement. So we recognize that many of us are joining from different places in Canada today and will not be able to acknowledge all the Indigenous lands our participants are living on. That being said, I would like to acknowledge that CCLA's office and the speakers for this event are in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. It is now home to many diverse First Nations, Inuit, and Métis peoples. In the spirit of reconciliation, we acknowledge the land that the Indigenous peoples have lived on and taken care of since time immemorial. We are honored to be able to live and work on this land. So with that, I would like to pass this over to our Advancement Director, Rosemary Oliver, who's going to give us some quick CCLA updates. So Rosemary, over to you.
Thank you, Michael. And I'm going to apologize. We actually should have had a land acknowledgement for Montreal because Anaïs is speaking to us from Montreal. So I apologize for that, and we will do better next time. Hi, everybody. I'm Rosemary Oliver. I work in the fundraising department at Canadian Civil Liberties Association and the Canadian Civil Liberties Education Trust. And I'm actually standing in for Howard Sapers, our new executive director. Howard started with CCLA, CCLET as our new ED in July 15th. And he wanted to be here today, but unfortunately he had a prior commitment. He will be with us at the next webinar, which is taking place on November 20th. That's a Thursday, and we'll be sending the invitation out for that a few weeks in advance. Howard wanted me to provide some updates in his absence, and as I said, you'll hear from him directly the next time. Bill C2, the Strong Borders Act, is something we've been campaigning on a lot. And a lot of civil society organizations have pushed back about this bill because it would infringe on the rights of refugees and migrants. And the government is supposed to be tabling a new C2 today. I don't know if that's already happened, not that current in terms of the news. And it was supposed to address at least some of the civil liberties concerns. So that's great for all of you who took action or pushed back against this law with your MP and made a protest in some way. We've also been busy with the Alberta book ban. There was a book ban that was proposed by the Alberta government, and that's written about in our new newsletter, which is at the printers even as we speak. Unfortunately, we won't be able to mail it to you because of the mail strike, but we will be sending a PDF version through email in the next week or two. So you can watch for that, and that will have an update about a lot of the different things that we've been working on. As you know, there is a mail strike. So for those of you that would normally make your donation around this time, if you're not comfortable going online and our website is ccla.org/donate, that's where you can make a donation. If you're not comfortable doing that, you can phone us or you can let us, yes, I'm going to say phone us or send us an email if you don't actually want to donate online. If you're able to send us an email, info@ccla.org, then we can get in touch with you. Either give us your phone number or give us some other way to contact you. The walk, have a walk for civil liberties that is happening on Sunday, October 26th. That's just a little over 2 weeks away. That's in Toronto. So those of you that are in Toronto, you may want to come out and join us. But we also have a virtual component where you can join us from across the country. And we actually have more people signed up across the country than we have in Toronto. So feel free to join the virtual walk or the one in Toronto if you can. And I think that's all I want to say because we're here to hear from Anaïs, and I want to do a proper introduction to my wonderful colleague Anaïs Bussières McNicoll, who's the director of our Fundamental Freedoms program. As part of her role at CCLA, Anaïs develops and manages strategic litigation in which the CCLA, as a party or intervener, endeavors to advance the law on fundamental freedoms, democratic rights, and mobility rights. She also advocates for fundamental rights and freedoms in various forums, including parliamentary committees and the media. She is deeply involved in CCLA's opposition to the increasing use of the notwithstanding clause in the Charter of Rights and Freedoms to override basic human rights. Anaïs believes that a society cannot be truly free and democratic without a transparent, accountable state that respects the rule of law and upholds charter-protected rights. She is honored to dedicate her professional career to defending these principles. Prior to joining CCLA, Anaïs was a partner at a national law firm where she practiced litigation with a focus on public and constitutional law, as well as civil law. She was particularly sought after for her contributions to complex cases at the appellate stage, especially before the Supreme Court of Canada. Anaïs was called to the Quebec bar in 2015 after earning her law degree with honors from the University of Montreal. She then completed a 2-year clerkship at the Quebec Court of Appeal. Please join me in welcoming Anaïs Bussières McNicoll, our Director of Fundamental Freedoms, and returning it over to her. Thank you.
Thank you so much, Rosemary, for the introduction, and good afternoon to all of you. It's really a pleasure and a privilege to have this opportunity to present some of the key issues that the Fundamental Freedom Program has been working on over the past few months. I'm also looking forward to answering any and all questions you may have at the end of this presentation. So as mentioned by Rosemary, the Fundamental Freedoms Program is devoted to protecting freedom of expression, protest rights, freedom of association, freedom of religion, democratic rights, mobility rights, and the rights to life, liberty, and security of the person from government overreach. This program also focuses on democratic accountability and on upholding the rule of law. These are definitely unprecedented times. Over the past few months, people in Canada have watched in astonishment as various pillars of American democracy have gradually crumbled. The recent developments out of the border, and frankly, in many parts of the world, are an ominous reminder of how fragile our rights and freedoms can be, and of how vigilant we must all remain. And the harsh truth is that Canada is not immune to authoritarian trends, which is why having a strong national watchdog for civil liberties and human rights, such as the CCLA, is so crucial right now. My presentation today will focus on some of the ways in which freedom of expression and the right to protest peacefully are currently under threat in Canada, whether through anti-protest bylaws, or legislation, or book bans. I will also update you on the status of key litigation that the CCLA has launched to hold the government accountable, including our well-known challenge of the federal government's invocation of the Emergencies Act in 2022, and our challenge of interprovincial travel restrictions adopted by Newfoundland and Labrador during the COVID pandemic, which was heard by the Supreme Court of Canada earlier this year. Finally, I will talk about the notwithstanding clause, what it is, why everybody in Canada should be worried about it, and what the CCLA is doing to fight back its growing use by politicians to override basic human rights and freedoms. So let's start with the anti-protest bylaws and CCLA's challenge to the one adopted by the municipality of Vaughan in Ontario. Anti-protest bylaws create bubble zones around various types of community gathering spaces. Within these zones, protests that are disruptive or offensive, yet peaceful, are prohibited. A handful of municipalities in Canada have already adopted this type of bylaws over the last couple of years, and many others are currently considering doing the same. Frankly, the declared purpose of these bylaws is to balance people's right to freedom of expression and peaceful assembly against the health, safety, and well-being of community members. And we acknowledge that this is an important goal. But in pursuing this objective, the bubble zone bylaws recently adopted punitively prohibit an extremely wide range of peaceful protest activities. So the CCLA recently initiated charter litigation against Vaughan's anti-protest bylaw, which we see as a prime example of everything that's wrong with bubble zone bylaws. This bylaw prohibits any individual from participating in a nuisance demonstration within 100 meters of hundreds of vulnerable social infrastructures, and they're defined within the bylaw, which includes schools, daycares, hospitals, and places of worship. Pursuant to this bylaw, an individual is liable for a fine of up to $100,000 for having uttered offensive speech at a protest, or for having participated in a protest in which someone else uttered offensive speech. That's how broad the bylaw is. And I want to take this opportunity to be clear. Of course, everyone in Canada is entitled to physical safety. In case of violence, threat to physical safety, or incitement to violence, the police can and should consider using their powers to protect public safety. But the police already have broad powers to fulfill their mandates. They did not need new bylaws. And the reality is that bubble zone bylaws are not really about protecting people's physical safety or their safe access to property, because that's already covered under the criminal code. What these bylaws are about is about prohibiting peaceful political protests, because some people find them disruptive, and they are about chilling and suppressing speech because some people find it offensive. These kinds of limits strike at the heart of what it means to live in a free and democratic society. And we believe, frankly, that they're unconstitutional. And before turning my attention to the next topic, I do want to express CCLA's sincere gratitude towards Stockwoods LLP, who is representing us pro bono in this litigation. So shout out to Nader Hazan, Daniel Gouch, and Olivia Miles for their outstanding work. Our right to express ourselves freely is clearly under threat in several cities across Canada. However, the newly proposed Bill C9 could expand this danger to all of Canada. Bill C9, which was recently introduced by the federal government, proposes to enact new criminal code offenses prohibiting intimidation near buildings primarily used by marginalized communities. At first, this sounds really reasonable, right? The catch is that the criminal code already prohibits intimidation, as well as criminal harassment, mischief, uttering threats, and hate propaganda everywhere in Canada. But this new intimidation provision goes much further than existing criminal offenses by criminalizing any conduct that is intended to provoke a state of fear in another person in order to impede their access to tens of thousands of buildings and structures in Canada. Frankly, the state of fear threshold is vague and subjective. This raises the question of what this additional criminal prohibition would encompass. Would it be triggered when a protest is particularly loud, when hundreds of people are present, when protesters utter unpleasant slogans? These disruptive elements could be seen by some, including the police, as evidence of an intent to instill fear in others. Yet, they are a constitutionally protected form of nonviolent, non-threatening expression and peaceful assembly that should neither be criminalized nor broadly suppressed in a democracy. This new provision could result in workers not being comfortable protesting outside of their places of employment. It could also prevent members of marginalized communities from protesting their own institutions. And peaceful protesters could be criminalized near places of worship, even when these buildings are being used for political purposes. Given the magnitude of the danger that Bill C9 poses for protesters' rights, CCLA is vehemently pushing back against this piece of legislation. Just this Monday, we sent a letter to the Justice Minister urging him to rethink this deeply flawed bill. And the letter was signed by more than 37 civil society groups. These organizations represent people from all walks of life, including members of the Black, Arab, Muslim, Jewish, to LGBTQIA+ communities, as well as labor unions and environmental activists. We will continue pushing back, and if this bill is adopted as is, all options will be on the table, including a charter challenge. One last thing I want to say about protest rights is that an important part of CCLA's mandate is also to educate people about their rights, especially when they have to interact with the police. And that is the reason why we have released a recently updated Know Your Rights guide for protesters. The new guide explains key legal rights when participating in protests, outlines the state of the law on peaceful assembly and free expression, and provides clear steps on what to do if detained or arrested. You can find it on our website. And this guide was done in collaboration with CCLA's Criminal Justice Director, Sheikh Rahim, and we're also thankful for the pro bono assistance of Arash Yassi, Teresa Danker, and Krishna Saravana-Mututu. Moving on now from protests, but still with respect to freedom of expression, you may have heard of our campaign against Alberta's decision to ban books from school libraries. In short, Alberta's Minister of Education and Childcare issued last July a ministerial order requiring all school libraries in the province to ban books depicting, including in writing, explicit sexual content. School libraries also had to ensure that books depicting non-explicit sexual content were unavailable to students below grade 10. So we're talking about students below age 15 to 16. In addition, books on sexual health education had to meet the government's narrow definition of non-sexual content in order to be permitted in school libraries. A few days later, CCLA sounded the alarm in an op-ed that was published in the Edmonton Journal, in which we called out this move as outright state censorship. Of course, not all sexual content is appropriate for students of all ages, but our point was that blanket bans are not the solution. We raised concerns that classics and thought-provoking works like The Handmaid's Tale could be banned from school libraries as a result of this ministerial order. Where it gets really interesting is that Alberta's Minister of Education responded with an op-ed of his own. He accused CCLA of mischaracterizing the ministerial order and of spreading false narratives. However, soon after he made his comments, the Edmonton Public School Board's list of books that would be banned as a result of the ministerial order was released. The list included more than 200 books, including, you might have guessed this, The Handmaid's Tale. Under pressure from civil society and the public, the Alberta government backed down and repealed its book ban. It issued a new ministerial order, this time focusing on books containing visual depictions of sexual acts. While some parts of this order are still questionable, it is a relief that the government will no longer censor the written word in school libraries. I'll now turn my attention to two important court cases in which the CCLA plays a major role. I'll begin with the Newfoundland and Labrador case. We challenged a few years ago, the CCLA challenged the constitutionality of Newfoundland and Labrador's 2020 travel restrictions intended to fight the spread of the COVID-19 virus. The law was a sweeping travel ban that only allowed residents, asymptomatic workers, and those granted special permission to enter the province. As a result of this travel ban, Mrs. Kim Taylor, a Canadian citizen born and bred in Newfoundland but residing in Nova Scotia, was initially denied entry to Newfoundland to grieve with her family and attend her mother's funeral. CCL argued before two courts in Newfoundland and the Supreme Court of Canada just this last April that the travel ban infringed Canadians and permanent residents' right to move around the country freely. These rights are protected under Section 6 of the Canadian Charter of Rights and Freedoms. We argued that this ban was unreasonable and unjustified in the face of less infringing alternatives. And to be clear, our point is not that charter rights are absolute or that the COVID pandemic was not a pressing issue. Our point is that even, and dare I say especially during times of crisis, government limits on charter rights must be rigorously justified. In other words, a public health crisis is not a magic wand which can justify any policy choice. Times of crisis are precisely when the civil liberties and fundamental freedoms that define our society are at greater risk. And we're still waiting on the Supreme Court of Canada's decision in this case. And what's interesting is that the court decision will come at a time where Canada is facing an unprecedented threat to its sovereignty. The need for unity is real, and there could not be a more important moment in our time to underscore interprovincial mobility and their importance and the importance of fundamental rights. Moving on now to what we've done with respect to the Emergencies Act this year, you may remember that the CCLA challenged the federal government's invocation of the Emergencies Act during the 2022 Freedom Convoy blockades. The Emergencies Act is an extraordinary measure that grants emergency powers to the federal government in exceptional circumstances. This act, which had never been invoked before in Canada, allows the federal government to enact wide-reaching orders without going through the ordinary democratic process, but only once stringent legal thresholds are met. We challenged the invocation of the Act because we believe that these legal thresholds were not met, and that the blockades could and should have been dealt with through regular policing and ordinary laws. In February 2024, the federal court agreed with CCLA that the government's decision to invoke the Emergencies Act was unreasonable. The federal court also agreed with CCLA that the governmental action resulting from the invocation of the Emergencies Act violated freedom of expression and the right to be secure against unreasonable search or seizure in a way that is not reasonable in a free and democratic society. Earlier this year, the CCLA was at the Federal Court of Appeal to defend its historic victory. We are now waiting for the Federal Court of Appeal's decision on the matter, and we do want to take this opportunity to say how immensely grateful we are for the outstanding pro bono legal services of Eva Krajewska, Brendan Chung, and Eric Arsenault of Heinen Hutchison Robitaille LLP in this case. And I should have mentioned when talking about the travel ban restrictions that we're deeply grateful for the pro bono representation of Paul Pape and Shantona Chowdhury from Pape Chowdhury LLP. Last, but certainly not least, I'd like to talk a little bit about our campaign against the growing use of the notwithstanding clause. As you know, the Canadian Charter of Rights and Freedoms protects key rights and freedoms of everyone in Canada. However, Section 33 of the Charter, commonly known as the Notwithstanding Clause, give lawmakers the ability to shrug off these important rights and freedoms by preventing courts from striking down laws on the basis that they infringe charter rights. This clause is thus nothing short of a charter override. Not all charter rights are subject to Section 33 of the Charter, but those that are submitted to this charter override are far from trivial. They include many of the most basic, essential principles needed in a free and democratic society. And some of these rights are ever present in daily life. They allow people in Canada to freely speak up about issues they care about, regardless of their opinions, aspirations, and political beliefs. They allow people to peacefully protest for their vision of a better world, to exercise their religion freely, and to collectively bargain for better working conditions. The prospect of the Notwithstanding Clause curtailing these rights has always been worrisome, but much more so now that several provincial governments and even a federal opposition leader have either promised to or invoked the Notwithstanding Clause. In Quebec, the government has preemptively invoked the Notwithstanding Clause to shield Bill 21, which bans public sector workers, such as teachers, lawyers, and police officers, from wearing religious symbols. More recently, the Quebec government has also mused about invoking the Notwithstanding Clause to shield its upcoming bill banning public prayer from charter scrutiny. As you can imagine, we have strongly opposed this upcoming bill, and we are ready to react whenever it's going to be tabled. In Alberta, just recently, a leaked memo showed that the Premier of Alberta might be preparing to use the Notwithstanding Clause to protect from charter scrutiny 3 discriminatory laws that prohibit gender-affirming care for minors, that restricts students from using chosen names and pronouns without parental notification and consent, and that ban trans women and girls from participating in sports. At the federal level, the current leader of the opposition has shown himself to be willing to make the federal government take the unprecedented step of invoking the Notwithstanding Clause to prevent harsh bail and sentencing laws that blatantly violate the Charter from being struck down by courts. These are just a few of the recent examples of ways in which the Notwithstanding Clause has or could restrict everyone's charter rights, to the point of making them meaningless in many circumstances. And of course, this is a complex issue because the Notwithstanding Clause is part of our Constitution, which cannot be amended easily. And this is why we have developed a multi-pronged approach to the problem focused on 3 items. 1, raising public awareness, 2, pursuing strategic litigation, and 3, advocating for legislative reform. When it comes to raising public awareness, the importance of this is because in a democracy, the electorate has the last word. So one way to fight the erosion of our charter rights and freedoms is to ensure that there is a political cost to invoking the notwithstanding clause. And this starts with raising concerns in the media each and every time elected officials invoke or publicly consider invoking the notwithstanding clause. We have also engaged in several initiatives. For example, in the context of the last federal elections, we released a letter urging all federal party leaders to commit to a public consultation on the future of the notwithstanding clause. Over 50 organizations, human rights advocates, and legal experts endorsed the letter, and we plan to continue collaborating with these stakeholders in the future. Our second, I would say, item or angle is through litigation. My colleague Harini Sivalingam, director of the Equality Program, is leading CCLA's efforts as one of the appellants in the Bill 21 challenge, in which we challenge the constitutionality of Quebec's law on state secularism. And our position is that there are limits to how the notwithstanding clause can be used, and that these limits can be found in our constitutional architecture. In other words, the notwithstanding clause does not permit governments from changing the basic structure of our constitution. We're headed to the Supreme Court of Canada in this file, and we already know that it's going to be a pretty heated debate with more than 40 interveners without even counting attorney generals. In terms of timing, we have filed our factum and we have received the intervener's factum, but I believe that a hearing date has yet to be scheduled. The last angle through which we're attacking this growing use of the notwithstanding clause is legal reform. So we take really a pragmatic approach to the current situation in case we are unsuccessful at the Supreme Court of Canada. And this approach takes into consideration the fact that a constitutional amendment is very unlikely to take place. So we have launched a national campaign calling on the Parliament and each provincial legislature to enact laws through which they will pledge to only use the charter override within certain parameters. So to learn more about this initiative, we invite you to go to our website and to consult the Save Our Charter campaign page. So to conclude, as mentioned, I've spoken about several key projects, but the Fundamental Freedoms Program has a lot more going on. And luckily, it's all on our website and our social media platforms. I do invite you to take a look at all the work we've been doing, and I hope you will find it as important and interesting as we do. We believe that now more than ever, Canada needs a strong and independent watchdog that will help support a robust Canadian democracy by defending rights, calling out injustice, and keeping power in check. For over 60 years, CCLA has been at the forefront in being that watchdog and holding government to account. And with your help, we will continue our fight for rights and freedoms so that all people of Canada can live in a free, inclusive, and vibrant democracy. Thank you so much for your attention. And I would now like to turn the attention back to you all and to open a conversation. I'm open to receive your feedback and to answer any and all questions you may have. Thank you.
Rick, thank you so much, Anaïs. And yes, so we have plenty of time for questions. So I again encourage you to place your questions in your chat. We'll try and get through as many as possible. So the first question is a question that I'll answer as it has to do with fundraising. So somebody has asked, can we direct our donations to specific initiatives? I think more needs to be done around minority rights. So yes, you can. So if you're giving online, we can, at CCLA or .donate, there is a section of what you people, just the notes section around your gift. If you want to indicate there that you'd like to give towards a specific initiative, we do allow people to give to our four key four advocacy areas of criminal justice, equality, fundamental freedoms, and privacy, surveillance, and technology, and also to our sister organization, CCLET, which is our education programs. So online, if you just want to indicate in the note section there that you want to give to that one of those specific program areas, in this case, that would be equality, that's perfectly fine. If you want to call us too, we can make that happen as well. Even if you want to mail us once the mail strikes over as well, if you include a note in your donation that you want to be directed towards a specific initiative, we can make that happen. So thank you for that. So the first question for you, Anaïs, is Doug Ford has threatened to use the notwithstanding clause to destroy Toronto's bike lanes. Why do you think so many provincial governments have started to use the notwithstanding clause for so many different types of legislation?
No, that's a good question. And I think the answer to that is the absence or near absence of political cost that was supposed to be tied with any invocation of the notwithstanding clause. So back when the notwithstanding clause was negotiated, before the Canadian Charter was adopted, there was this perception that it would be used as a last resort in exceptional circumstances, and that it would be extremely costly from a political standpoint for governments to use the clause, because they would be seen as governments that infringe and override their population's charter rights. The reality and the sad reality is that in the, I would say, the last few years, 5 years, we've seen an increase in the use of the notwithstanding clause, and not necessarily a great political cost tied to it. Which is why part of the efforts that we're doing is we're trying to raise public awareness about the dangers of the clause. And from a standpoint of, sometimes when the clause is invoked to target a specific marginalized communities, for example, trans youth or Muslim women, it's easy for the rest of the population to feel like, well, this isn't really about me, so it's unfortunate, but life goes on. And part of the educational work that we're doing is we're saying, wait a minute, you might be next, because if this type of power is left unchecked, government could decide to ban speech that is critical of people in power, or they could decide to ban the presumption of innocence. So that we're talking about key basic human rights that are absolutely central to what living in a free democratic society looks like. And my last point with respect to this, as you see, I could go on and on. What we're seeing south of the border right now, I think, is a very ominous notice of how dangerous it could be. The notwithstanding clause does not exist in the US. So technically, we're even more vulnerable to authoritarian trends than the United States of America. So it's definitely a very, very important issue.
Yes, it's very important, very current. The next question we have for you is this person is asking, saying, I agree with you that the right to protest is very important, but what about the right to not feel threatened outside your place of worship? How do you balance these two rights, the right to protest and the right to exercise your freedom of religion?
I agree completely, and that's why in the presentation I explained that our position definitely is that everybody in Canada is entitled to physical safety. And I'm also adamant that, I'm also here to defend freedom of religion, and part of being able to exercise this right, this constitutionally protected right, includes an ability to safely access your place of worship. But people often do not know that obstructing access to any property in Canada can lead to police action. It can constitute mischief. So protections are already in place in the criminal code. Freedom of expression and freedom of peaceful assembly are not absolute, but we should always be very skeptical of overly broad limits on those pillars of our democracy. And the last thing I'll say with respect to this is, yes, these rights have to be balanced with each other, or with other important societal goals. And we also always have to keep in mind that the price of living in a democracy, or the cost of living in a democracy, sometimes is that we have to deal with language that we disagree with, or with protests that we find offensive or disruptive. And part of the constitutional protection awarded to freedom of expression and freedom of peaceful assembly includes this very right to use our public civic space, to voice our opinions, including in a way that is unpleasant, and to cause some reasonable level of disruption. And what is not reasonable is when a protest becomes violent or physically threatening, or incites violence. But again, protections already exist in those examples under the criminal code.
Thank you. And moving back to the notwithstanding clause, there's a current case going on. So this was leaked a couple of weeks ago. What plans are being made for if and when the Alberta government invokes the notwithstanding clause to attack the rights of trans youth?
So in Alberta, that's a good question. The reality is that right now we're headed to the Supreme Court of Canada in the Bill 21 challenge. part of the issue there is whether or not a government can preemptively invoke the notwithstanding clause. So that means that usually a government should have as an objective to respect charter rights. And when the government decides to limit charter rights, the limitations should be reasonable and justified in a free and democratic society. And the government should have the courage, frankly, to defend its laws in front of the courts. And the courts are the guardians of the Constitution, and they're the one who get to decide if a government has crossed the line and infringed on rights in a way that is not justified. So part of the issue here is that we're seeing that Alberta is getting ready to invoke the notwithstanding clause preemptively. So the Supreme Court of Canada might have something to say about this type of invocation in the Bill 21 challenge. Some of you may know also that there's a You Are Pride challenge going on in Saskatchewan with respect to a similar anti-trans, I would say, law banning the use of pronouns at school without parental consent. And there again, the notwithstanding clause has been invoked in a preemptive way. And this case is also trying to make its way to the Supreme Court of Canada. So all of that to say that before we make an informed decision about the steps that we're going to take in Alberta, we kind of have to see how how things play out at the Supreme Court of Canada. Having said that, it's definitely a priority. Our executive director has sent a letter to the Alberta Premier urging her not to use the notwithstanding clause in Alberta.
Perfect. And so the next one is another case that's been ongoing for a while. You had touched upon it previously. Are there any further updates around Bill 21 and the Quebec religious symbols ban in Quebec?
So yes, so as mentioned, it's going to the Supreme Court of Canada.
Yeah.
More than 40 interveners, which is, I think, unheard of. Some experts have labeled this case as the most important charter case of the century. So their words, not mine, but it's definitely a very important debate. To my knowledge, we don't have a hearing date just yet, but various facta have been filed.
Thank you. And the next question, again, I'll answer this one. So they're asking, TikTok is king when it comes to content platform and reach. Do you have any social media presence? And if not, what do you need to pull this off? So we don't have a TikTok currently, but we are on Twitter or X now, Facebook, Instagram, Blue Sky, and LinkedIn. So yes, we post regularly on social media, like we have pretty extensive social media reach. Our keyword basically is CanCivLib, so CanCivLib on all our platforms. So if you search across those platforms for CanCivLibs, you'll see our social media present. So check us out, follow us. We're updating it basically daily with goings on for CCLA. So next question for you, Anaïs. Is there a watchdog looking at another dangerous loophole in the law that's been exploited in Alberta under the guise of mental health care? So cleaning up the streets by incarcerating and forcing treatment on people. Police are on the front lines of this. There's very little to no oversight. It's a slippery slope, and civil rights are being waived for anybody who's deemed mentally ill.
Mm-hmm.
Yeah.
Absolutely. And I mean, I wish Anaïs Bussières, the director of the Equality Program, was here today, because she's the one leading the charge with respect to involuntary treatment and the ways in which it harms people's right to life, liberty, and security of the person, but also their right to equality. So yes, I invite you to look up on our website what we've done. There are a few, like I would say, parallel bills and initiatives and challenges going on in Canada right now. I know that there's a challenge in British Columbia that the CCA is currently not involved in, but that we're following very closely. And I know that Alberta, and I believe also Ontario and Quebec have either introduced new legislation increasing the ability to force involuntary treatment onto people, or are either considering doing this. So we're definitely, it's a sensitive issue, it's a difficult issue, but we always approach it with the understanding that for example, people suffering from substance abuse and addiction, the Supreme Court of Canada has recognized that it's an illness that deserves care. But if you don't involve the person who's involved, who's suffering from the addiction in the solution, experts are saying that it's just not going to be effective and it's going to be dangerous. So it's an area where we feel like our principled approach to charter rights are totally aligned with what the lived experiences of community members are and what expert advice is.
Thank you. I think we may need a bit more background to answer this question, but we'd like to answer this question for you. So I'm just going to read it out. And if Anaïs, maybe you're aware of something more about it, but if not, maybe this person can give us more background in the Q&A. How and why the government is banning music promotion across countries? So they no longer have rights to promote their own music now. Are you aware of anything currently happening in the news, or?
No, like, is this about the kneecap ban? Or if it doesn't have to do with this, I'm afraid I'm not sure I understand the context.
So yes. So the person who asked this, maybe if you could give us a bit more background on that, we'll get back to that question. If it is about the kneecap ban, we can comment on that. But for now, we'll go to the next question. So this is a bit of a long one. So hello, I understand that in the recent filing submitted to the Supreme Court of Canada in the case of Quebec secularism law, Ottawa has argued that the constitutional limits on the notwithstanding clause Ottawa has argued that the constitutional limits on the notwithstanding clause preclude using it to distort or wipe out rights and freedoms guaranteed by the Charter. In response, Premier Doug Ford said to legislators that legislators are supreme, not judges ruling on stuff that shouldn't be in front of their courts. So what are your thoughts on the Premier's response?
I would say that we live in a society where courts are the guardian of our Constitution. Of course, legislatures are democratically elected and they have a lot of powers. Now we're stuck with the situation where we have a notwithstanding clause that was added at the last minute in the Charter, and that, yes, is part of a constitutional compromise that allowed the Charter to be there. However, even before the Charter, we had protections for basic human rights and, for example, freedom of expression in Canada. And CCLA's position is that our constitutional architecture is based on some of those key fundamental rights, and that the notwithstanding clause cannot be used and should not be used to override some basic human rights. So it's definitely a complicated debate, and it's also a very heated one. And the Supreme Court of Canada ultimately will have to decide if there are limits to how the notwithstanding clause can be used, and if so, where those limits can be found. Our position is that those limits can be found in the architecture of our Constitution.
All right, and this is another question coming about the notwithstanding clause. It's an important and very timely topic, it seems, which is good. So Quebec seems to unfortunately be leading the way with in the preemptive use of the notwithstanding clause. My sense is the general public in the province does not understand that this is extremely problematic based on general conversation. Are there any specific education efforts by the CCLA in the province to be more present in this space?
Mm-hmm. Bonjour Hélène Beauchemin, je vois que la question vient probablement d'une francophone, donc je me permets de la saluer. And then I'll answer it in English for the benefit of everybody. I agree completely. And part of the work that I'm trying to do is to increase CCLA's media exposure in Quebec, and to talk about those difficult topics to the population. And I'm always very open to suggestions as to the best way to do that. Also, we have a wonderful team at CCLA, which is called CCLET, the Canadian Civil Liberties Education Trust. Essentially teachers who are just traveling across the country, including in Quebec, to educate students about charter rights and democracy. and the risks of the notwithstanding clause and the danger it poses to our democracy. So yes, I feel like both from an advocacy standpoint, which is my focus, and also from an educational stance, which is more the focus of CCLET, we're really trying to raise awareness in Quebec about the situation. One thing that's really interesting, I won't be able to quote the exact numbers and who did the survey, but I remember that there was a very serious institute that did a survey at some point in Quebec saying, here's what Bill 21 is about. Do you agree with it? And a small majority, so 51%, I think, of people surveyed said, yes, we agree with Bill 21. And then the next question was, who should have the last say about whether or not this is constitutional? Should it be the legislatures using the notwithstanding clause, or should it be the Supreme Court of Canada applying the Canadian Charter of Rights and Freedoms? And there you had a majority of Quebecers saying, no, the Supreme Court of Canada based on the Charter. So I agree that there's a disconnect sometimes between what information is given to the people of Quebec and how the like people of Quebec care about charter rights. And I feel like if we can find a way to explain to them that this is not about Quebec's, from my perspective, not about Quebec's unicity or distinctiveness in Canada, but more about a basic commitment to upholding human rights and civil liberties, I feel like we could do a lot of mileage in the public opinion in Quebec.
Thank you. And yes, so CCLET is doing great work trying to educate people across Canada and Quebec as well. So I encourage you to go check out their website at cclet.org to learn more about them. So this is an interesting question, I guess, surrounding just communications with MPs and MLAs and MPPs. So what are the kind of rights and obligations of federal, provincial MPs, MPPs, MLAs if you write to them or like draft a petition to them? Like, is there obligations for them to reply or guidelines around that you're aware of?
Yeah, that's such a good question. I wish I had the answer.
Yeah.
The reality is that we're kind of just like you guys. Like we find emails, we try to speak to people, we send emails. Often we get at least like an automatic acknowledgement of receipt. And sometimes we are successful and we get to talk with MPs or MPPs. Sometimes we don't. So it's definitely a challenging process, and I can see how citizens who are interested in what's going on right now and want to be heard by elected officials may find it very difficult to actually convey their message and be heard. Whenever you feel like there's something that you want to say that has to do with systemic issues that relate to charter rights, I do invite you to use to contact the CCLA. We have a page on our website dedicated to public inquiries. So we're not able to answer to every request that we get, but we certainly read them and we analyze them. And when we see a systemic issue that we could use our platform and our voice to fight against, we definitely try to do that.
Perfect. Thank you. And this is actually a really interesting question especially relating to the guide, the protest rights guide that's been going out and the kind of the general climate around that. So how is like the idea of causing fear in others like objectively assessed in the law when they're making?
Well, if somebody finds out, I would love them to tell me. And that's kind of one of the core issues we have with Bill C9 is that having the intent to provoke a state of fear is a very unclear, vague, subjective threshold. It's not defined within the bill. So frankly, it can mean anything and everything. And it's going to be left in the hands of the police, who have a history of disproportionately targeting marginalized communities and overly submitted them to over surveillance and over policing. It's going to be up to them to decide if they see like there was an intent to provoke a state of fear. From our perspective, we feel like many legitimate protest activities, loud protests, huge crowds, unpopular or offensive slogans, all of that are protected forms of expression, and we believe that they could be captured under this new provision. And we don't know how the courts will apply this provision, but if you have bad law well, the courts have to apply the law unless there's a charter challenge. And that's where the CCLA might come into play.
And so this is a question more generally about the idea, what's happening in the world around us. Like the CCLA, we're obviously concerned about the rise of authoritarianism in other countries. And if so, but what are we trying to do to prevent that?
I mean, that's such a good question. The reality is just like there's this saying that when the US sneezes, Canada catches a cold. And I feel like we can already see this happening. I gave some examples earlier today, but also one very recent example is how a University of Alberta professor was put on involuntary non-disciplinary leave after engaging in legitimate public critique of Charlie Kirk's legacy. And the professor was ultimately reinstated, but this is a very troubling attack on academic freedom. And it's very similar to what we have heard happened in the US following the tragic murder of Charlie Kirk. So we definitely see like many countries, I feel like, are further along. But one key aspect of our work is to track and resist authoritarian trends in Canada as well.
Thank you. And this is a question, next one may be better directed to Harani Sivalingam, who is our quality program director, but Anaïs, maybe you may know something about it. The Alberta government has used the disability credit to claw back AISH benefits to disabled persons, so rendering the benefit not a benefit at all. Is there an action planned to protect disabled people in Alberta?
So you're right, Michael, this is outside of my field of expertise, but what I suggest that we do is that we take good note of this question and we make sure that it's on Harani's radar. Her radar is very effective, so I doubt that there's something happening in Canada that she doesn't know about, but we'll double check.
Thank you. Yes. So if you want to get in contact with us, info@ccla.org, and we'll get that question answered for you and see what put on Harani's radar. So next question is, again, it's about the notwithstanding clause. So they're thanking us for our important work on Section 33, the notwithstanding clause. Do you agree that one of the fundamental problems with the notwithstanding clause that it is also contrary to Canada's prior international human rights treaty obligations under the International Covenant on Civil and Political Rights? Is this like a point you raise in our advocacy? So
yes. I mean, historically, CCLA's advocacy has been focused on Canadian soil and Canadian rights. However, we don't operate in a vacuum. We know of international law, and we certainly know of Canada's international obligations as per international law. And yes, basic human rights were not an invention of the Canadian Charter. They exist everywhere elsewhere in the international space, and they have been recognized there. And they've been recognized as, and I don't know if my translation is going to be right, but like inalienable. So agreeing to a clause that allows government to override rights that are supposed to be inalienable certainly raises a lot of questions.
So this is going to be the last question. So apologies to everybody for not being able to get all the questions. We had a lot of questions actually for this, which is fantastic. So if you didn't get your question answered, feel free to send us an email to publicinquiries@ccla.org or info@ccla.org. All that information is on our website, and you can find it pretty easily, and we'll try and get back to you. So this last question is, my sense is that we have rarely, if ever, seen so many rights under attack from so many levels of government. So how are you working with other Canadian organizations to try and challenge this?
That's such a good question. I mean, we have an ecosystem of civil society groups, allies who work together to try to fight back. The reality is that much if like all of us basically are nonprofit organizations working with tiny budgets and limited capacity, but we care very deeply about the work that we do. Also, CCLA our focus is on civil liberties, but also equality rights, criminal justice, privacy and surveillance and technology. And all of the principled positions that we take, we always want to make sure that they are anchored in the lived experiences of communities everywhere in Canada. So a huge part of our work is also to be in touch with various communities, especially marginalized communities, to make sure that we have their perspective on the position that we take. Sometimes often we take unpopular positions. So we're not saying that we we take principled positions based on charter rights and interests and freedoms, but we also want to make sure that whatever we do for hopefully the greater good of everybody in Canada. So with that in mind, working with other groups such as EGAL and LEAF and NCCM and I mean many more is absolutely crucial.
Thank you so much, Annie. So with that, I'm going to pass it back over to Rosemary Oliver for just a quick wrap up.
Yes, thank you very much, Michael, and thank you, Anaïs. And Anaïs, I want to thank you very much for that quick tour through very deep and profound and complex cases that you're working on in fundamental freedoms. And before I pass it back to you to see if you have any last few words you want to say about fundamental freedoms before we stop the webinar, I just want to remind people that there is the Walk for Civil Liberties on October 26th. If you're in Toronto, you can come out in person, and Anaïs will be there as well. She's joining us with other CCLA staff, board members, and volunteers on October 26th. You can join the virtual walk. And please donate online if you haven't made your gift this year. That's my last pitch. And I'm going to pass it over to Anaïs to just any last words you want to say about the Fundamental Freedoms Program and fundamental freedoms in general. And thank you for the presentation, Anaïs.
My pleasure. And I mean, thank you, Rosemary and Michael, for organizing all of this. I'm really just so privileged to have to show up and talk about the work that I do, but I know that a lot of work goes into making this possible. So a million times thank you. And thank you to everybody who was there and for this like really interesting engagement and questions. I wish we could discuss this all day, but I'm very also happy to see the amount of questions that I got about the notwithstanding clause, because it's an issue that has been keeping me up at night. And I'm very happy to see this level of thought-provoking discussion that we were able to have. So thank you so much for being here today.
So, all right. So thank you everybody for coming. So we're going to end it here. So just a reminder, this was recorded. We will be sending out the recording if you want to watch this again or send it around. We'll send it out around a week. And we do have another webinar coming up next month. So keep an eye on the mailing list. We'll send out the invite around that in a couple of weeks. And we hope to see you out for that one too. So thank you everybody for coming. Hope you have a great rest of your afternoon. And we'll end it here. Thank you.